Pete's going to kind of give us, bring us up to date on where things are with Doreen.
Yeah.
You need you want the mic for him?
I don't think I need it.
Because we're going to videotape.
Yeah, would you rather I use it?
Yeah.
Okay, very good.
For the video, yeah.
Okay. Doreen is now at home. She is still in custody, but for the remaining 54 days of her official incarceration period, the current incarceration period, has been converted into a home confinement situation. So she is technically in the custody of a halfway house in Detroit, where she has to report to twice weekly, and from whom she has to get permission for any movements outside of the house that she undertakes during the course of the next, at this point, 5 weeks. It's an unpleasant situation, but it's a lot better than being in a prison camp, where she had spent the last 14 months. However, unfortunately, this is not the end of the situation for Doreen. The government, of course, is desperate to get the false testimony from her. That was the crux of this whole affair in the first place. Lacking that false testimony, it's never been able to assess any taxes against Doreen and I, even for the years that they're trying to force her to perjure herself about, which go back to 2002 and 2003. So many, many, many years ago. I'm the most intensely resisted American that the IRS has ever had to deal with, and yet they're unable to collect the dime in taxes from me because neither I nor Doreen has ever declared our earnings to have been from activities subject to the tax. The most telling evidence of the truth of the tax that I can frankly imagine. So they want that testimony. They want that false testimony very, very desperately. And so not only was Doreen convicted for refusing to produce that false testimony and under the auspices of that being contempt of court in the first place, but as a special condition of supervised release, the government asked the sentencing court to order her to create that false testimony within 60 days of being released from custody or go back to prison. And so as of November 2nd, Doreen will have either allowed her First and Fifth Amendment rights to be trampled on and will have capitulated and created the perjury that the government wants from her, or she will perhaps and likely face re-imprisonment. And for an indeterminate period of time, frankly. We don't even know what that would mean. It could be very, very lengthy. So for right now, she's home in much better circumstances than had obtained for the last 14 months, but still with this sort of Damocles hanging over her head. And we're going to attempt to, of course, have this special condition removed. And the interesting thing about her case that many of you will already know is the fact that the orders that Doreen was convicted of criminally resisting are not only unconstitutional and unlawful, not only did the trial judge have to accept and deliver a government-requested instruction to the jury that they not consider the unlawfulness and unconstitutionality of the orders in their deliberations. But no court has ever declared these orders to be anything but unconstitutional and unlawful. None of them have ever gone so far as to confess to their unconstitutionality, except insofar as this jury instruction was concerned, which I think any rational person would recognize that as a tacit acknowledgement of these orders being unconstitutional. If you have to instruct the jury that it must disregard the unconstitutionality of the order in order to convict, you are basically agreeing that these orders are unconstitutional. That's rudimentary logic of kindergarten level. But at the same time, no court has ever dared or been compelled to admit outright that the orders are unconstitutional. They've played a game of whack-a-mole every time this issue has been raised, and it's been raised over and over and over again over the years. Each of them refuses to rule, refuses to address the order, or the constitutional question of these orders. In a few cases, the trial court cases, trial judge cases, they would refer to an appellate court, and the appellate court would refuse to rule on it in the latest case on the basis of collateral bar doctrine, where they argued that they didn't have to address the constitutional question because Doreen had already disobeyed the order, and under this completely court-created doctrine called collateral bar, they reasoned that therefore they can disregard or don't have to consider the lawfulness of the order. And their argument is that if we did that, if we allowed that, then people would disregard court orders at will, waiting to have another court, an appellate court, rule on whether they actually had to obey them or not. Well, yes, that's how the system is supposed to work. If an order is not necessarily lawful or constitutional, no one should be compelled to obey it at all until it's been determined whether it's lawful or not. But the courts don't like that because they view that as infringing on their power, which of course it does. But, you know, they're not supposed to be gods. They're supposed to be subject to the rule of law, just like everybody else. They simply chafe under that restraint and have figured out this workaround. We will be moving the sentencing court to remove the special condition, and we're in a unique or an improved position in that regard because Doreen has not yet disobeyed this special condition command, and therefore the collateral bar skirt can't be hidden behind by the courts in dealing with it this time. So.
Aren't you still under appeal? You've got an appeal coming out?
No, the appeal is exhausted. The appellate court said collateral bar says we don't have to address the constitutional question, so we're letting everything go. We're letting everything stand.
So basically, you ask the United States Supreme Court, and they say, "Oh, geez, we're too busy."
The Supreme Court said that the first time this issue was brought to them when the orders were initially issued. I took it all the way to the Supreme Court at that point, and they were too busy to hear the case. Now, you know, that in and of itself means very little. The Supreme Court gets 10,000 applications or petitions every year. They hear about 75 cases. So the ratio is, you know, 0.075% of the cases that are brought actually get heard by the Supreme Court. The Supreme Court has said itself, everybody knows our refusal to hear a petition means nothing about the merits of the case. Nothing. And no one can refer to it in any other way, even though judges do all the time. The DOJ does all the time. They'll read a petition denied as though that meant something, and of course it meant nothing. But so the Supreme Court has been their ruling from them was sought once, and they denied the petition. In this case, we have yet to decide whether to go to the Supreme Court for Doreen's specific case involving the same orders. The Sixth Circuit is the court that ruled so far on the appeal, and they hid behind the collateral bar skirt. And so, however, as I said, the new challenge to the special condition that will be going into action shortly has the benefit of collateral bar not being available in this case. This will be the first time that there will have been an opportunity to go directly in without the protection or the evasion opportunity of a court to say, well, you already disobeyed the order, therefore we don't have to consider the constitutional question. In this case, Doreen has not disobeyed this command. It won't have until November.
Do you think, by chance, we know that the courts now, either court, state or federal, they're operating on administrative flaws, but to claim Article 3 court would be a different issue?
In some cases, they're operating administratively, and in other cases, they're not. In the current situation, Doreen's trial court is an Article 3 court. There, of course, is the issue of the legitimacy of her being under a legal duty that will have arisen in this case. But taking it as, you know, for sake of argument, that she was, then this court, which is a criminal court, is operating as a standard judicial branch created constitutional court. She's not being held liable for taxes or anything like that. I mean, she's not being treated like as in a tax court situation, which is indeed an administrative court. She was charged with contempt of court. That's all. Criminal contempt of court. There was no tax charge involved in her case at all.
Do contempt of court, does it have a certain statute of limitation, but limits to how much they can confine these people?
No, actually, there's no limit at all. It's one of the very, very, very unusual statutes that has no statutory sentence range. She could be sentenced to life.
So you can do life, 30 days, or life.
Yes.
So when you compare this to what they did to Peter Schiff's father?
Well, Irwin Schiff's case was distinguishable, very much distinguishable. For one thing, it wasn't a contempt case; it was a tax charge, and actually a series of tax charges. And unfortunately, Irwin made two dramatic, what might be called strategic errors in the things that he did. First, he was wrong about the tax. I can't be blamed for that. I think he was sincere and well-meaning and believed he was correct about the tax. I firmly believe that. I've met Irwin several times. I admire Irwin hugely. I mentioned him, or did, in my early editions of my own first book on the subject of the tax, as having been a very significant leader in helping people understand that there is an issue to the tax question that needed to be looked at and merited it. Second thing, though, that he did was he actually helped people create documents that were invalid. And again, not willfully, but nonetheless he did do it. And the courts, in ruling on his cases, improperly disregarded the willfulness component and held him to charges just on the basis of the acts alone, as opposed to the criminal intent issue. And he was imprisoned, convicted and imprisoned, and the conviction upheld improperly because of the willfulness element not being given the significance.
He didn't really help people, I think.
He filled returns out for people.
Didn't he? Main
He
thing
absolutely
was
filled out the paperwork and did everything.
he refused to stop printing his books.
He was never charged with printing a book.
But the order was to stop printing it, and he refused, I think.
He may have been enjoined on an illegal tax or abusive tax shelter argument. Yeah, that's possible. I don't recall the details of that.
Wasn't his argument the 16th Amendment, or
No offense.
Schiff's argument basically was that the income tax applied to corporate profits. That was in a nutshell.
Where he came from?
In a nutshell, that was his view. And of course, it's not true, but again, he sincerely believed it to be true, in my opinion. Mm-hmm. And he should not have been held to any charges for having a wrong opinion. That's not the way our system is supposed to work. But he did complete tax forms for people. And,
Well, do they have a definition of profit? The government or
the tax? The tax falls on gains and quote unquote income. Income, in order to be subject to the tax, the gain, it has to actually be a realized gain. It can't simply be an increase. It has to be an outright. It has to qualify for what people would normally consider to be profit. But more significantly, it has to also come from the conduct of taxable activity, which is to say the exercise of federal privilege. That's the real key to the tax issue. You can exercise federal privilege and not make a gain and not owe anything as a consequence. And you can make gains that don't involve exercising taxable privilege or federal privilege and not be subject to the tax. But if you exercise federal privilege and you make money doing it, make a
So,
realizable
you know,
gain, then you're subject to the tax for
The
the
definition of
activity.
profit, though, is if you buy something for 50 cents and sell it for $1, you make 50 cents. That's profit. But if you exchange your labor for money, that's an even exchange.
Unless you're doing it as the conduct of a federal privilege, in which case you have no right to do it whatsoever. You're only doing it because the government is allowing you to do it. And that, they can then decide how much of that constitutes gain and how much of it doesn't constitute gain.
Yeah.
And that's what they've done. They've given you a certain exemption amount, they've given you a certain degree of deductions, and everything above that is a gain, by their definition. And you're playing the game in their court if you are using their privilege in order to enjoy those earnings.
So Aaron Schiff was right in saying that there was no income tax for individuals. He just didn't.
No,
recognize that it was
no,
an
there
excise tax.
No, there absolutely is an income tax for individuals. Every person that works for the federal government is doing it on the permission of the federal government. They're exercising a federal privilege, and they're subject to the tax.
Tax on that income.
It's an excise tax on that activity.
Okay.
But only if you're working for the government.
Or if you're using government property or government powers or in many other ways. You're invested in federal corporations. There are lots of different ways of making income. If you get interest from a national bank, you're making income. You're engaging in a federally privileged activity. You're doing it with permission of the government. You're investing in their operation, and you're getting a gain
So
from
pretty
it.
much all your investments are taxable.
No. There are many corporations that have nothing to do with the federal government. And any investment in those, any gains. You'd have to look them up. The definition of a federal corporation is one that is controlled by the federal government.
So it's just
Controlled by means the federal government appoints the majority of the board of directors of that corporation, like Fannie Mae, Freddie Mac,
but not necessarily.
but not Sears, nor necessarily Halliburton. No, although I don't know what the makeup of Halliburton
From
is.
the federal government, right?
And they can be the nexus of those contracts can create can convert those activities into income. Absolutely, not for the people who work for Halliburton necessarily, but certainly for investors and officers of the corporation. Absolutely, and there can be a complex nexi that create that necessary linkage to be connected to the performance of the functions of the public office.
They are.
Definition of trade or business. I'm sorry?
There are two definitions, one of a taxpayer, one of a non-taxpayer.
There's a formal definition of taxpayer. There isn't a formal definition of a non-taxpayer, but certainly by rudimentary logic, if you're not a taxpayer, you're not. Then you're a non-taxpayer. I'm sorry.
There's a case law.
There are cases in which non-taxpayers are referred to,
Yeah.
but there is no formal definition in law of what a non-taxpayer is. There is a definition of what a taxpayer is, and so by extension, if you're not that, then you're a non-taxpayer.
Exactly.
Yeah, but that's almost a meaningless term, and it actually is very distracting for people. The tax doesn't apply on a status basis. It doesn't apply because you're a something or you're not a something. If you are engaged in taxable activities, to the degree that you are then within in the eyes of the law, you are a taxpayer within that narrow context and to that narrow degree. And so, and the government will always try to refer to everybody as a taxpayer because it likes to presumptively treat everything everybody does as having done a taxable activity. And so it just presumptively uses the expression taxpayer every time it speaks to anybody about anything. From their standpoint, if you have business talking to them, then you must be a taxpayer, because otherwise you generally don't have any business talking to them if you're not one. So they call everybody that. But the problem with that is one of the problems with that is that from that people sometimes imagine that there is a status of personhood that is a taxpayer person, and then anything that person does is taxable, and then there's a status of person that's a non-taxpayer person, and nothing that person does is taxable. None of that is true. Barack Obama is a taxpayer insofar as he is President of the United States and gets paid for doing that. But if he were to work at the 7-Eleven down the street from 1600 Pennsylvania Avenue in the evening to make a few extra bucks, he would not be a taxpayer as far as that activity is concerned. That money would just go into his pocket. It wouldn't have anything to do with anything. It's not a taxable activity to work at a 7-Eleven, even in the District of Columbia, and even if you're Barack Obama. It's not a taxable activity to work at a 7-Eleven. Being President of the United States, that's absolutely a taxable activity. But what you do in your off hours isn't. So there's no such thing as a status-based structure where, you know, one person is subject to the tax and one person is not subject to the tax. It all depends on what you do.
The thing is, when the IRS writes you a letter, they put your name in all capital letters.
And sometimes they don't, actually. And I have a bunch of examples on my website of official documents from the IRS and from many other government agencies that are not in all capital letters. Because capital letters have nothing whatsoever to do with anything. They do that because they don't like the possibility of the confusion of a lowercase l with the number 1, for instance, and for other reasons. That's the only reason that uppercase thing ever gets done on any document.
But this case law has said, and all capital letters are non-rigueur in the sense that they are corporations.
No, there actually is no case law that says that. There is some false citations that are actually fictional that have been floating around on the internet for decades. Well, for as long as the internet's been out there and floating around in the tax honesty community for decades, that say that this is a thing. There is no case law that says that. None whatsoever. Again, there's no such thing as status that has anything to do with the tax. There's no, you know, this person is subject and that person is not subject. There's no such thing as, you know, if you're a corporation, you're subject to the tax, and if you're not a corporation, you're not subject to the tax. Some corporations, some of the things that some corporations do are subject to the tax, just as some of the things that some people do are subject to the tax, and some of the things that some corporations do are not subject. Same thing with people. Anyway, so I was, yeah.
A couple of things you want to mention, your website, and you said you put a new video up this week.
Yeah, losthorizons.com. That's the website. To those, you know, watching this film, go there. You can view. Right now, we currently have posted about 1,200 complete 100% refunds received by Americans across the country over the course of the last 13 years. From both federal government and 34 state governments, which is the total of the state governments that actually collect an income tax, along with a handful of municipalities that also collect it. And these are 100%. That means not just all nominal federal income taxes that were withheld, but also Social Security and Medicare taxes, which are just income taxes by other names. And those are representative of what now amount to several hundred thousand refunds of the same kind that have been being accumulated by people over that 13-year period. Complete refunds appear in Americans' mailboxes on a daily basis, and have been doing so even while I and my wife have been subjected to intense harassment and harm over the course of all of that time. In fact, on the website at the Every Which Way But Loose collection, you can see episodes in which the federal government in particular engaged in very strenuous resistance activities against educated filings reclaiming refunds of property withheld. And you can see the outcome of those, the eventual surrenders by the government after doing everything that you could imagine to try and resist those claims and refuse to pay the money. Pretty serious proof of the pudding. I did just post a new video, actually one in which several people in this room appear. It is people reflecting after Doreen's sentencing in April of 2014. Or I'm sorry, April of 2015. And those excellent people, Anna, David, Glenna, and some others who are not here, spoke of the really just surreal experience of being in a courtroom in which corruption held sway and and just palpable evil was working its will in defiance of the law, and it's a short little film, but well worth seeing, I think. And there are a number of other films about Doreen's case that are posted at varying lengths and degrees of complexity. Anyone who's interested, go to lostrisings.com/istandwithdoreen.htm, and you'll be able to see a great deal about her case and these excellent films. So, thank you.
Can they bring up your newsletter from the website, or do the FBI email us to get the newsletter?
No, anyone that visits lostrisings.com, on the top navigation bar, you will see a link for news. Just click there, and it will bring up the newsletters. It's a great place to see the latest complete refunds. I tend to post a few anyway, most every week, in order to highlight some things that any particular refund illustrates. I no longer am in the habit of just posting them willy-nilly with, as I said, 1,200 in place already. It's long past any need to prove the point. The point is as thoroughly made as is humanly possible, and a failure to recognize it at this point is willful disregard of reality. Okay, David? Yeah.
Did you want to mention the next Sunday?
We are having an open house next Sunday from 1 to 5. We'll be grilling some hot dogs and allowing those interested to welcome Doreen home and thank her for her service on behalf of all Americans and their rights. She has been standing tall and firmly on behalf of her and everyone else's rights of freedom of conscience and speech and the right to due process. One of the things that people don't often recognize about the demand that has been placed on Doreen to create false testimony, to get specific about that, she was ordered by a judge to declare her earnings to be from activities that qualify for the tax, something that she knows perfectly well is not true, and something that the government has never been willing to say itself over anyone's signature, not once. Not only is that a speech and conscience assault, because of course she knows that this isn't true, and yet she's being ordered to say it and to swear to the truth of it, to swear that she believes it to be true. But it's also a due process and Fifth Amendment issue, because the government wants to use this compelled false testimony as the basis for it claiming that Doreen owes it money. Again, something that it has never been willing to say over its own signature or any officer's signature, because it knows it's not true. But it's trying to force Doreen to say it so that it can then say, well, you've agreed that you did taxable stuff now, so now we can take some money from you. This is exactly the same as any litigant in any lawsuit being ordered to agree with their opponent's facts. Something that no one would tolerate under any circumstances. If you were being sued by Sears and a judge said, and Sears asked the judge, make that person agree with what we're saying happened. It's just incredible. But that's exactly what's going on in this case. Yeah, it's just outrageous.
Is there any way to take the offensive on that? File charges against one or more of these judges?
Good question. Good question.
Delinquent duty or something
Let me speak to that. Several months ago, I had a meeting with a representative from Attorney General Bill Schuette's office, attempting to get Schuette to charge the federal official malefactors in this case with some of the crimes that they're committing under Michigan law. Michigan law makes criminal subornation of perjury. It makes criminal witness tampering. It makes criminal what's being done to Doreen. Not only what has been done to her, but what's being done to her right now with this special condition that, again, is attempting to compel her to lie under oath for the benefit of the government or go to prison. These things are illegal under Michigan law. Bill Schuette has been stonewalling me ever since. That's the effort to
Well, what about a
hold.
civil case?
Well, that's a different matter. That's a different matter. And I have drawn up the brief for that civil case for any competent attorney, litigator, that cares to step forward and do the patriotic thing here. I am not a litigator. I know the law better than anyone on the planet in this area, but I am not a litigator. I'm not somebody that knows. I don't know the mechanisms. I beg your pardon?
I don't think a bar attorney is going to touch this. You're going to have somebody that knows the law without having to rely on their living being on a bar. Maybe
Well,
a non-bar attorney.
Well, a non-bar attorney is not going to get into a courtroom, and the bar attorneys take on cases of this kind all the time. In fact, when I was first being assaulted with efforts to enjoin my book, the Center for Individual Rights, a Washington D.C. public interest law firm, helped me out with those cases, and we defeated 4 efforts by the government to shut my book down. And of course, these are bar attorneys. There's no bar attorneys do the right thing. Any attorney is going to sometimes have difficulty taking in something that is frankly alien to their training and their experience. Attorneys don't get taught the realities of the tax law. Most of the people who are teaching attorneys have no idea of the realities of the tax law. Everybody's in the same boat in that front. Everybody who's alive today, pretty much, grew up being misinformed and very, very deliberately conditioned with misinformation about this subject. Their entire lives, they've had nothing but misinformation, and it's reinforced by everyone around them. Their CPA, their attorney, their HR department, their mother, the people at H&R Block, the IRS. So there's this enormous body. This is the taproot of the government of Leviathan today. It's the taproot. It's the thing that is most heavily defended by the government. Everything rests on this stone for them. Everything. Without this, if you look at the historical record, the record of the size and significance of the federal government, and all the state governments as well, is a hockey stick. There was the big joke about Al Gore and his climate change hockey stick being kind of fraudulent. In this case, it actually is a hockey stick. 140 years, the size of all government combined in this country was below 10% of GDP. That being a direct reflection of the scope and power that it represented. And everybody else, the people had 90% of everything. The government got less than 10%. Government in total got less than 10%. I'm sorry?
To what year?
Until 1943. 140 years. And then the income tax misunderstanding got put into place in large part with the adoption of the current Tax Withholding Act of 1943, which capitalized on about 30 years of very, very vigorous disinformation that was being kind of pumped into the American consciousness, along with the traumatic effects of the Depression, World War II, which we were in the midst of, public education, which the first generation across America had gone through the public schools at that point. And that hockey stick, that under 10% thing, suddenly goes like this. It skyrockets. Suddenly, from an average over the entire history of the income tax from 1862 to 1942, an average filing rate of below 8% of the population, all those years combined. 2 years later, it was 93%. 93%. That was the difference. And that was the thing that made that hockey stick of government size and its consumption of GDP and its relative power go from a straight line into this about a 60-degree angle, where it's stayed ever since. We went from a government small enough to drown in the bathtub to Leviathan eating everybody's dinner in that period of time, and for that reason alone. It's not because they started printing money, it's not because of any other thing, because nothing else changed. It was just that. So they defend this more heavily than anything else they do, anything else they have. And so it's no surprise that, you know, your average attorney, he doesn't get taught this stuff. He has no clue. He's as ignorant of it all as the average IRS worker is. None of them know anything about this. Now, you know, some of them are intelligent guys. They, you know, live the life. They're in America. Some of them have picked up some things, for sure. But generally speaking, you can't, you know, automatically diss the legal profession just because the legal profession doesn't buy into or automatically walk in and say, oh, yeah, I know you guys are right. You know, they just don't know.
They generally don't want to.
Well, they absolutely don't. There are other reasons. No, you're right. You're right. They're capable of being sanctioned.
But if you're talking about, you know, like a legal firm like the ACL, then they will go out and fight.
Except they won't fight this one. They love the income tax, right? The ACLU loves the income tax.
Like mine either, but nonetheless, you know, we're fighting different games against the same enemy.
No. It's, you know, part of it is they don't know any better, and it's all new to them, and you know they don't necessarily have time to, you know, ramp up and learn, you know, an entirely new picture of the universe. And part of it is because they take cases that are easy for them. I mean, whenever possible, they take cases that are easy for them. And, you know, just like everybody else does. Everybody takes the path of least resistance. The law profession is no different. If they're given the opportunity, you know, well, here's a case where I want you to, you know, fight the 800-pound gorilla, and, you know, you're going to be arguing things that they do not want to hear, and you know, even things that are unusual in the, you know, overall American milieu, and you know, the odds of winning, considering, you know, how much resistance you're going to be up against, you know, are slim appearing at least. Or you can go take this this case where you're going to plea it out and get paid you know, nice bucks for basically filling out paperwork, and that's going to be, those are your choices. Which one are you going to take?
Well, I know a lawyer
I'll take the plea bargain.
is licensed to practice law in the state of Washington for basically taking cases, taking the wrong cases.
There are a bunch of things that militate in the legal profession that militate against being what people in the, you know, activist community you know, end up concluding that all lawyers are you know, shills and work for the government or something, whatever. They don't work for the government, and they're not all shills, and they're not all bad guys either. It's just the incentives that they operate under are skewed to create outcomes that, you know, activists can view poorly. So you know, the civil case thing is, you know, absolutely, I would love to have it. As I said, I've already written a brief that, you know, exhibit rich. One of the things we did during Doreen's trials was we secured a whole bunch of admissions. One of the most interesting being that, you know, that as part of the orders that Doreen was convicted of resisting was it involved a declaration by the judge who issued them as to the contents of my first book. She made specific, this was all DOJ written. She never wrote the ruling. The DOJ wrote it, admitted that in court, by the way. She just signature stamped it. But one of them was a declaration as to some arguments that my first book supposedly makes. It doesn't make those arguments. But the government wanted to allege that it does so that it could then say, oh, well, see, this book says this and it's not true. I agree that it's not true. My book says that it's not true, but it doesn't say that it is true. But they wanted to say that. So they made these declarations. Well, we subpoenaed this judge to testify in Doreen's second trial, at which point she was obliged to admit she never read the book.
Oh.
That's on paper now. She never read the book. She made findings as to what the book says, and then later, which appear in these orders, and then later was obliged to admit that she never even had seen a copy of the book.
So that should be a civil suit?
Well, it's in the civil suit. It's in the thing I've written up for a civil suit. So, again, I would love to have a competent attorney that is an experienced litigator, knows how to prosecute a civil suit, step up and prosecute this suit. This is important. This is a very important case. Just as I would really like Bill Schuette, the Attorney General of Michigan, to prosecute these people for their crimes. That's one of the things that the federalist structure is intended to is how it's intended to operate. The states are supposed to be the counterweight to the federal government. When the federal government is abusing its power, the states are supposed to step in and balance that power. It isn't supposed to be left to some individual to get mugged in a dark alley by any government operation that cares to start beating on someone's head. Right now, that's how it happens. The states just they kick back, and the federal government beats on anyone it wants to. That's just what happens. That's not supposed to happen that way. Hamilton himself said in one of the Federalist 49, I think it was, said that people can rely on, they need not fear the power of this government because they can rely on their state government to interpose itself and protect them from that kind of thing. And that's what Michigan should be doing right now. When these people are committing crimes against my wife, Michigan should be stepping up and saying, hey, you know what, those are crimes in Michigan. And you've done them in Michigan. That means you're criminals under our law, and we're going to prosecute you for that. And that, believe me, that kind of thing would stop. The first time one of these officials was thrown in a Michigan prison, ended up in Jackson for something like this, whether it be suborning perjury, as in Doreen's case, or any other offense that these federal officials arrogantly commit against citizens of states, just because nobody stops them. The first time one of them ended up in a state prison for 10 years, that would be the end of it. Yeah. You'd have a transformation in this country of the relationship between citizen and central government. But so far, nobody's doing it. This is a perfect case. It's a perfect case. I hopefully,
we don't have a perfect attorney general.
Well, we don't have a perfect attorney general, but I'd like to think that, at some point it'll occur to him, hey, this is good politics even. Because there are an awful lot of people that are very bothered by the status quo, by the relationship that the federal government, has with citizens today, which is, completely overwhelming and unchecked.
Maybe he just thinks it's too big for him. He doesn't.
Could be. In any event, that's the answer to the question. That's what's going on. An attempt is made to, charge these people, and we'll see what happens. I can't do it myself. I wish I had the ability to. It would have happened a long time ago. Schuette won't do it so far. So anybody that has any influence with the Attorney General, please, throw your 2 cents in. And as far as the civil thing is concerned, I am absolutely hoping that an attorney of competent experience will step forward and take this on. I think that it'll make his reputation, and I think it'll make him a ton of money as well, because I would be asking for $1 billion for what's been done to my family over the course of all of this. $1 billion would be not even remotely close to enough. So, anyway, that's all I got. Thank you all, and next time.
Thank you, Pete.